Okay, good morning everyone, and welcome back to the second day of our annual conference. My name is Elias Deutscher. I'm a lecturer in competition law at the UEA Law School and also a member of the CCP, and I'm very delighted to chair this morning's very illustrious panel, which will discuss one of the most topical issues in competition policy, namely killer acquisitions. And this topic has stirred quite a lot of controversial debate in academia, and I think academic discussion on this topic has been really a driver also then for potential policy change. So we have seen quite a number of very fascinating policy initiatives in Europe, in the UK, but also perhaps in the US, adopted in order or envisaged in order to address concerns around killer acquisitions. And so we will have 3 papers on this topic by 3 experts in the field, and each of the speakers will present for about 20 minutes, and then we will have 5 minutes per paper for questions from the audience, move on to 2 discussants, and then open up to a broader discussion. And without any further ado, I'd like to introduce the first speaker, Kai-Uwe Kühn, who is a professor in economics at the UEA Law School, at the UEA School of Economics, and deputy director of the Center for Competition Policy, and he also acted as a former chief economist at the European Commission, DG Comp. And please, Kai-Uwe, I invite you to take the floor.
Okay. Should we speak from here or from up there? From up there. Okay, so I can see. Okay. All right. If I could have the slides, that would be great. First of all, I'm really glad that we kind of have this panel. Oh, I have to do that one. Click. Man, that's astonishing. It works. It's you know, this is, you can see it's going to be a high-tech paper, quite clearly. But I think we're going to have today a panel which I really like, which is kind of about more going to much more into the practical issues and implementation of what one could do and not do. And this is kind of the spirit of the paper that I want to present as well. I should first of all have a disclaimer on this because kind of openness on these things is important these days. So this comes out of consultancy work that I've done for Google, where the interest of Google was just kind of getting some systematic data on acquisitions behavior and comparison between different industries out into the public domain. So in order to do that, it's something that you might actually not do. You might not write a paper like this for academic journals necessarily, but what we then did with that data and how to think about how to use this data in order to create some criteria on which type of transactions one might want to pick up on in order to analyze them for the possibility of killer acquisitions was something that kind of came from me and where they actually took no influence whatsoever in putting that together. So the question here was, if we're addressing the killer acquisitions issue, and if we're skeptical like me that one says, look, all you do is you invert the burden of proof and say, well, if it's so good, why don't they prove it? And you don't think that makes a lot of sense, and we might go into that why I think it doesn't make a lot of sense. Then whatever you do, you have to create some set of criteria by which you're selecting the cases that you will actually look at and investigate. And for that, you need some kind of measure that captures, at least in a rough way, what you might think a killer acquisition is. And so generally, we kind of think of killer acquisitions as having young startup firms and taking it off the market to prevent them from becoming competitors in the future for relatively large platforms. Right? And there's an implication of that, of something that one should be seeing in those transactions. Namely, if both sides think this is the type of innovation that they have that can make them a real competitor to a large platform, they should actually be growing really fast in a very short period of time. And if they're able to grow very fast in a very short period of time, we should see that in the value of the transaction. Namely, despite the fact that the firm is very small now, the value might be enormous. And those are exactly the types of transactions where people have wondered about what that means. If you're kind of thinking, for example, about Instagram, a company that was acquired for billions at a time where they had absolutely no revenue whatsoever. Okay? So the question is, can we kind of this intuitive idea, which economically makes a lot of sense, namely I should be seeing reflected in kind of the value relative to the current revenues of whether this has a potential to be a killer acquisition. Can we do that systematically, and can we just use that using, to a large extent, publicly available data to create something that is a threshold for taking up cases that doesn't just depend on market shares, which it can't, and as you will see, just a value question doesn't do it either. But here it's really value relative to current revenue, or what people call multiples, that might actually matter. And how do you have to look at that in order to create that? That's really all what the question of this paper is. It doesn't say anything more. It doesn't say how you should be dealing with those firms in those circumstances. It also doesn't say that it's a sufficient condition to find that this is a killer acquisition. But we should be thinking about this as a way of filtering out those cases where it's worthwhile to have an investigation to see whether it may be a killer acquisition. Okay, so it's all about a feasible approach that we have in order to screen, to detect which transactions are worth creating. I want to convince you that that's completely implementable as something that competition authorities could do as a screen, and therefore could also put into reforms of legislation. So the basic idea I've already told you, it's targeting outlier deals. So I said if a firm is a likely future competitor, acquire and target know that. That means if you have a really high value in the future that's going to come out, that's going to be necessary in order for you to be a credible competitor. And if the startup knows that they have that potential, they're going to ask for that money as well. So the obvious screen is target outliers in the deal multiple distribution. And I'm going to show you that there's a problem with that, namely the deal multiple distribution is not going to tell you everything that you need to know, because a deal multiple of 10 when you're earning $500,000 means a lot. Something a lot different from a deal multiple of 10 when you're earning $1 billion. The second one is much harder to achieve than the first one. The first one in consultancy can probably fairly easily achieve when they're decent, but it's not going to mean that they're kind of a massive competitor. So what I'm going to show you is that there's actually, when you're looking at the distribution of multiples relative to the actual revenue that the targets have, you actually get a lot of structure in the data, a surprising structure in the data that even makes it very obvious that you should be looking for certain benchmarks there. So let me go further on that. Let me tell you just a little bit on the data. The data is basically publicly available data. We spent a lot of time trying to see whether we could use multiple data sets from data providers to generate larger data sets and fill holes that they have in one another. That doesn't work very well. So in the end, because of the richness of the data set, because we also wanted data about the number of employees, we settled on the CapIQ M&A data set, and did a little bit of matching with the ICON M&A data set in order to add some data points. Note that this is always going to be selective. It is not the case that any of these data sets include all of the small acquisitions that firms make. So for example, in a case like Google, a lot of the transactions are not going to be in there because there are things that people call acqui-hires. Those are things like very small firms. There's an owner, maybe 4 employees or something. From the point of view of how this is discussed, it's usually like hiring someone that you really want to get in. And it's, in the US, very tax advantageous than to buy the firm, because you can basically, in what you're paying for the firm, give the future employee a lot more money, because that comes at a much lower tax rate. So there's a real advantage in these. They tend to also have very, very small values. That's the reason why they're not being picked up here. And so in terms of what we really want to look at, don't matter in the same way as other things. Now, what's going to be important for us here in order to kind of ask the question, what could be a killer acquisition, is that we're benchmarking it against something. And we could benchmark it somehow within the group, but you wouldn't want to basically say, look, we're benchmarking GAFAM acquisitions against GAFAM acquisitions overall and ask for the outliers in that distribution. That would be a little bit weird, because we would want to we're concerned about GAFAM and want to benchmark them with some other firms that are more similar, which means let's think about the tech industry. But a lot of GAFAM these days also look a lot like conglomerates. And so conglomerates may be a group to compare, which is what we did. So we took kind of a comparable group from the technology area of the CapIQ, from the conglomerates area, and then also as a comparison pharmaceuticals. Why did we use as a comparison pharmaceuticals? The reason for that is really that we have a lot of evidence in pharmaceuticals that we have killer acquisitions. There it matters a lot less to do an exercise like this, because the transactions are so big that they're usually picked up. And there's usually the pipeline of products is being looked at and so on and so forth. So they're kind of the way that the scrutiny works is actually quite adapted to what's happening there. But we also wanted to see whether pharmaceuticals, in which we're really thinking about products that are taking off the markets being much more obviously substitutes. We have in technology much more often products that could be seen as complements but might be potential substitutes in the future. And so this ambiguity between complementarity and substitutability plays a much bigger role. So it's not obvious that these sectors are directly comparable. And so it's interesting to see how pharmaceuticals in that type of analysis of outliers perform. So here I wanted to show you that there are really 2 sources of heterogeneity in the deal values and in the deal revenues. You're kind of seeing the red line, that's pharmaceuticals. Those deals tend to be in distribution significantly higher than those of all others. And if you're just looking at the value distribution, then the GAFAM deals actually tend to look very similar to those in the other tech areas. This now looks a little bit different when you're looking at revenues. So one of the things that sticks out with GAFAM is that the distribution is much more tilted towards smaller deals, right? So the revenues tend to be significantly lower, which is going to give you higher multiples, right? If you're looking at the pharma deals, they're actually pretty large. So if you're looking at the distribution here, and this is a log distribution, right? Just in order to kind of see something properly. So the pharma deals are actually a lot larger than the deals of others. But GAFAM is also here distinct in terms of the others. And now you could then just look at the resulting distribution that you get in terms of the deal multiple. And there you see that kind of GAFAM and pharma looks relatively similar. GAFAM even higher deal multiples than pharma. But it somehow comes from different reasons, right? So you have large deal multiples for pharma with high revenues, right? So the deal multiples for pharma and for GAFAM aren't directly comparable here, because the distribution is for a shifted distribution of revenues of the target companies relative to the GAFAM firms. So this is not telling us that the problem of having very high deal multiples that we should be looking out for is more so for GAFAM firms than for pharma. because the key information, well, the pharma might have the 1 billion transaction that goes to 10 billion, while the GAFAM has the one that goes from 1 million to 10 million. That difference is not reflected in this data. So we're not getting the full structure. And so the real insight here is that you have to look at both dimensions at the same time and kind of look for a given revenue what outliers are. Okay? And then you're getting these wonderful clouds of dots, which I always like, that kind of illustrate the data points. And they show you that there's a lot of structure in there. So look that on top of this, of course, the red dots go much further down than you might see because the blue ones are a bit on top. But you're kind of seeing that the highest deal values for any given revenues are actually in the chemical industries, right? In the pharma industry, right? So that's the red dots on top. You're seeing, when you see the dark blue dots relative to the light blue dots, the dark blue dots are GAFAM and the light blue dots are tech companies in general, that mostly they're lying kind of in the middle of that cloud of dots, only that they're much sparser when we're getting to higher revenues. So GAFAM firms, most of their transactions are with lower revenue firms, but for given revenue, they mostly lie within the range that you're also seeing for tech firms. There are outliers in there, so if you look at some of the top points, so if you're looking at something like 6 and go up there, the top point is a dark blue GAFAM point, sorry. But you're also seeing that there are kind of these clear upper bounds for these. And so what you can do, and that's going to be the strategy, to kind of estimate where the 95% of these observations for tech firms generally, not for GAFAM, are below, and then say, let's call everything that's above that as an outlier. And let's see what kind of firms we're getting out of that. Okay? Now you might say, that's a problem because if we have Instagram, we're not going to catch them because they have zero, so their deal values are infinite, right? And it's not always the case that every firm that has zero value is going to be an outlier in that sense. But you can do the same thing with employment. It gives you a very similar structure. Here's that structure for employment. And you see almost exactly the same, and it coincides to a large extent. So what you're getting in terms of the list of these firms as outliers, you're going to get as a list of outliers also for other firms. So what we've done then is just a kind of simple regression that is basically saying what for every level of revenue is the 95th percentile of the conditional distribution going vertically up, and then say everything that's, and what we've taken is the blue line, because that blue downward sloping line is the line for, the middle one is the line for the tech firms, the general tech firms, and say everything above that are outliers. So if you look at the yellow dot kind of in the middle, that's a Facebook transaction that's up there. So you see a lot of Facebook transactions that are in terms of the yellow bits that are up there. You see a couple of those blue ones, which are Google transactions. And I'm going to show you in a second what some of these transactions actually are. So let's go to that list. And what you see almost immediately, and I'm sorry, I need to kind of put my glasses on to see it on this small screen. It's actually, this is unusual. It's easier for you to see that than for me here. This is, so what you're seeing is that kind of some of our favorite transactions that we might want to look at, like Waze for Google, where a lot of people have had their concerns, which was never kind of really looked at. WhatsApp, Instagram, they all appear on this list of outliers. Okay, and what you're seeing there is that these large outliers like Instagram, so there's no number actually for the revenue multiple, but Instagram has a very significant target employee multiple. You have Beats being pretty big in that context, in Apple, for example. But you're also seeing some of these being transactions that have actually been looked at, like the Microsoft LinkedIn merger, the Microsoft Skype merger that happened when I was at the commission, where kind of people had a very close look at it and kind of decided that, for example, in the business video conferencing software area, this transaction wouldn't give rise to concern. Okay, so you have a list here. You can look at individual ones, and I want to kind of, just in order to show you the usefulness, kind of go through a couple of examples that also shows you that this is indeed a screen in order to see what you should look at, and that it makes sense to look at it, even if in the end you come to the conclusion that you don't think it's problematic. One example from the CMA is the Alphabet Looker Data Sciences transaction. It's a particularly interesting one because the CMA could pick it up and others couldn't. All right, there was kind of in the public domain a lot of talk about why should Google buy something that gives it more data. That was a misunderstanding. This is a data science company. That's mostly an issue of data science, and the CMA very quickly came to the conclusion that data science is so fragmented that this wasn't a problem for the data science market, but there was potentially, and that in my view was really the only theory of harm that one could look after, is the potential for foreclosure for other companies that would need Google data so that they could foreclose other data science companies from using that data and therefore leveraging market power. Now, what Google said in that context is what the transaction actually was all about. Thank you, that 5 minutes is perfect. What this transaction was all about was to support their cloud business. The CMA looked into that. They saw the board documents that were about this. It was very clear that that was the motivation. And they also looked at the incentives for foreclosure, decided that there were not incentives for foreclosure, and therefore cleared the transaction. Now, the theory of harm is a completely sensible one to go after in this context, right? And so I think it's one of an example where you say, look, if we have a screen like that that's systematic and we look at this, we're actually capturing something that makes sense. I want to give you another example of something that was kind of never scrutinized, but there was some discussion about, is Amazon PillPack. I don't know whether you know what PillPack is. PillPack was a fairly successful startup in the online pharmacy business. And there was a bit of a race who would buy up PillPack, and CVS, actually one of the big pharmacy chains in the US, was actually trying to buy them. And that would have been clearly a very problematic transaction because they were threatening to kind of generate competition in a fairly concentrated market of pharmacies in the US. And you know, here you could ask the question, what's happening with Amazon? Certainly this was one of those things where there was a clear complementarity there in the ability of Amazon in getting these pharmacy products delivered faster through its network and going together with a pharmacy that had actually done really well in terms of being good at providing the services. And so this is one of those transactions that would have fallen under it. Makes perfect sense. But here the question is, some people always say, can you look in the future or not? Well, here we're looking in the future in a way that we're doing in lots and lots of other transactions. And so you would be perfectly able to do that. And I think if we're looking at the Facebook examples that we have in that list, I think if one would have gone deeper into internal documents, as was done in some of the hearings in the US, those documents would have led probably to a more critical assessment than we have now. So kind of overall, I kind of think both in the direction of preventing intervention that is not necessary or unhelpful, and at the other time filtering out transactions that are problematic. This seems to be something that would actually work at exactly that margin. The question that comes up is, should one just really leave this to GAFAM? If we're looking at transactions that are problematic, aren't there transactions also in the tech world generally that may be problematic? Therefore, we did the same approach also to see what's in that 5% top multiple distribution for tech firms overall. And you also see a couple of transactions, the biggest one for Cisco systems with Cisco ArrowPoint communications, where you really ask yourself, should we not have looked at this and seen whether to intervene? This was in 2000, where Cisco is completely dominant in internet routers. However, there's a new technology that comes up that allows preferential routing of certain data challenges, and challenges Cisco that doesn't have that technology. Now, there's several providers of that, and ArrowPoint just has the best technology that is around. Cisco turns around and purchases them for purchases them to get the new technology. Revenue at that time is 21.2 million. Deal value is 5.6 billion. This is the type of thing that we get concerned about in GAFAM, but there's no reason not to get concerned about that in other transactions as well. And I think one of the contributions that this is making is that we can actually have something that's a horizontal filter that's much more neutral to the actual transactions and where they come from than some of the discussion is these days. And I think we're kind of getting potentially enforcement biases by having such a narrow view on GAFAM. And I think this is one of the examples that's useful to broaden that out. Okay, so I'm at the conclusions. I think there is a system here that is actually implementable, that actually has things that competition authorities could decide on how to use. Like, it doesn't have to be the 95th percentile if they think the 96th percentile is just as good. We had internal discussions about bringing in minority shareholdings at the commission when I was there, and it was all about kind of how many transactions is this going to bring if we're having certain standards. You can do that here. It's implementable, the data is there. It's not that difficult to actually have that scrutiny. It limits kind of the burden also on companies, because if you ask companies, do you really think having those transactions under scrutiny is that much more problematic and unreasonable? I think a lot of them would say no. I don't think any of the GAFAMs would object to something like this. And so I think, despite the fact that this idea is very, very simple, I can even see how you can kind of put it into law, because it's very close to the way that we've been doing screening on value. It's just that you shouldn't be doing it on value alone in order to filter out the right transactions. Thanks very much for listening.
Thank you, Kai-Uwe, for this fascinating presentation, and also for putting forth a practical screening tool for merger policy. And I think we will afterwards also have a discussion on perhaps its implementation. Is there any urgent question in the audience? So I think we have time for one question.
And we have three.
And we have three. Perhaps we have one question now, and then we return to the other questions after.
Yeah, thank you. I'm Peter Ormosi from CCP. Sorry, this is probably a little bit of a techie comment or suggestion, but because we're looking at distributions of revenue, firm size, I was thinking that that's a process that's likely to follow a power law distribution, and that's quite neat because analytically, power law distributions have got characteristics that are making it easy to work with. So things like firm size, city size, and so on. So really my question is, there's some research on power law distributions which show that if, let's say, there's random growth in firms, that will result in firm size distribution, which follows power law. So what you could do is compare the power law exponent, or let's say the acquired firms and the acquiring firms. The reason I'm saying this is because power law distributions are scale invariant. So if you find a difference in the exponent, it will mean that there's something different in the underlying growth process. And a kind of the economic literature behind this is Javier Gabe, and there's some really nice papers on it. But I do wonder that even with simple data sets just like yours, you could look at this and it could inform you whether the two types of companies are actually on different growth trajectories. Sorry, it's just really kind of long-winded suggestions.
I think it's intriguing and interesting, but I think somewhat divorced from the purpose of the paper. Right? And remember, it's also it's the deal multiple distribution. It's the deal multiple relative to the and I'm not sure whether that would have that property. But with some of the others, you're looking at value distribution and so on. I would think so, and you would probably kind of see very strongly that there's a difference between pharma and the tech industry.
Okay, thank you. I think we come back to the other questions after the other presentations. I would like now to invite Andriani Kalintiri to take the floor. Andriani is a lecturer in competition law at King's College, and I think she's one of the experts, not the experts, on evidentiary questions in EU competition law. She has published a very fascinating book on this topic, and also an extremely interesting article on analytical shortcuts, and I think this also ties in very nicely with the discussion on screens and screening tools in merger policy. Andriani, the floor is yours.
Great, thank you very much, and good morning, everyone. I'm really delighted to be participating in this excellent conference. And as Elias mentioned, my own background is in law. So the question that I'm going to discuss in my presentation is as legal as it gets. And that question is whether we should rethink the burden and the standard of proof in merger control. Let me clarify already that this is a question that arises not at the screening stage, but arises at the decision-making level. So when we have to actually make a decision as to whether the merger should go ahead or not. So this is a question actually that has been posed quite a lot in recent years, and before I share some reflections, I just wanted to give some context, what has triggered this discussion. And in a nutshell, as we are probably all aware, the answer lies in the strong concerns that several commentators and stakeholders have expressed about under-enforcement in merger control. So there are concerns that merger control, merger enforcement has been too lax, and that competition authorities have failed to detect and prevent harmful transactions, in particular by big tech companies. And the thinking here is the reason why this has happened perhaps is because the rules on evidence, the burden of proof, the standard of proof are too demanding and too difficult to satisfy. Now, as I say, these concerns very often they have been linked to killer accusations, and they have been also flagged up in all the major reports that were published in the last couple of years. So the EU experts report, the UK Furman report, the US Sicily report. But I just want to say that it seemed to me that the concerns that have been expressed in relation to mergers go beyond killer accusations. So some people have said we may have been too lenient in relation to vertical mergers, perhaps, so we need to rethink the rules. So I think killer accusations is probably the most prominent area of perceived or actual merger under enforcement, but it's by no means the only one. So assuming that we agree that there is an under-enforcement problem that we need to worry about and try to fix, one can think of a number of solutions to this problem. And all the solutions that I'm going to discuss essentially are meant to make it easier for a competition authority to block a merger that they think is harmful. And so a first solution in this regard is to shift the burden of proof and to require companies to demonstrate why the merger should go ahead. Another solution is to lower the standard of proof. What this means is that it would allow enforcers to establish harm with a lesser degree of certainty about the facts of the case. And then there is a third solution, which is to lower the substantive threshold for the assessment of mergers. So to say we're going to intervene even when there is a lesser risk of harm in this particular case. Now, I want to add that these solutions are not mutually exclusive. In principle, they can be combined. But the point is that each one of them, independently on its own, it may lead us to the desired outcome, if the desired outcome is indeed to try and make it easier for enforcers to block mergers that they think are harmful. However, I think, at least in my view, it's crucial to appreciate that not all these solutions are created equal. So it seems to me that in order to critically evaluate their merits, it is important to understand what the burden of proof is, what the standard of proof is, and what kind of considerations inform their design. So I thought it would make sense to say a few words about the concept first. And starting with the burden of proof, in simple words, this is merely a rule that tells us who has to prove something. And you might be thinking, why do we need such a rule in the first place? And the answer is quite simply because decision makers, as we know, oftentimes they have to make decisions in the light of incomplete information, in the light of uncertainty. So absolute certainty, it might be an ideal, but it's not really achievable in practice. And when you make decisions under conditions of uncertainty, there is a chance you might get it wrong. So in this sense, the burden of proof is a tool that helps us to reduce decision-making errors, but also allocate the cost of these errors between the parties through its two manifestations. So this is probably a bit too legal, but in principle, the burden of proof has two dimensions, what we call the legal burden or burden of persuasion. And that quite simply indicates the party that is going to lose the case if there is a fact-finding failure or the court is not convinced. And typically the legal burden lies with the party that claims the applicability of a provision. So the claimant claims a substantive rule, the defendant may claim the benefit of a defense. But we also have a second dimension, that's the evidential burden or the burden of producing evidence. And typically this shifts between the parties during the proceedings, depending on their claims and what evidence has been produced. And the idea here is that the evidential burden lies with the party with the better access to information. So the party, within their sphere of knowledge, the information lies, has an obligation to bring it forward. So the burden of proof tells us who has to prove something, but it does not tell us when the evidence should be deemed to be enough. And this is what the standard of proof does. It's another evidence rule. It helps us also to deal with factual uncertainty in adjudication. And this, depending on how it's conceptualized differently in different jurisdictions. But in principle, the standard of proof indicates the degree of probability or belief that we must achieve based on the evidence for the evidence to be deemed as proof in the eyes of the law. Okay, so it tells us basically what is the threshold of evidence that the party with the legal burden has to satisfy for their allegations to be deemed factually true in the eyes of the law. One small note about that, it's important not to conflate the standard of proof with the substantive legal test. So in mergers, that would be the significant impediment to effective competition or substantial lessening of competition. And this is a point that I will come back to later. And finally, I just want to say a few words about presumptions as well. A presumption in technical terms, in evidence terms at least, is just a mechanism that allows us to satisfy the standard of proof. So the way presumptions work is when we know that B is generally true, when A is true, perhaps the claimant doesn't have to show B. They can just demonstrate that A, the basis of the presumption, has been satisfied to the standard of proof, so it has been established to the standard of proof. And then from that, we infer that B is also true. So that's very simply what a presumption is about. Now, It's important to appreciate that decision makers, of course, when they make decisions, they draw inferences from the evidence all the time. So all types of factual inferences, that's just part of the adjudication process. But what is different with presumptions is that the inference is mandatorily drawn. So the decision maker is bound by the inference. So they need to accept B if A has been established. So that's one thing. And then the second thing is that the presumptions if the burden of proof onto the other party that then has to try and rebut it by producing relevant evidence. Now, when we design evidence rules or when we think about evidence rules and whether we should change them, generally there are three broad values that we aspire to, and that is accuracy, efficiency, and fairness. So in simple words, we want to have evidence rules that will lead us to accurate findings, accurate conclusions, but also rules that do this in a manner that is efficient and fair. So ideally, all these values will be satisfied. So for example, the reason why, as I said earlier, the evidential burden is on the party with the better access to information, it does make a lot of sense. This leads us to more accurate conclusions. It ensures that relevant information will be brought forward. And it's also efficient. Or when we rely on presumptions, when a presumption has been properly adopted, it can also expedite enforcement without compromising on accuracy or fairness. Or if you think about the standard of proof, we know, for instance, that in certain settings, like in criminal proceedings, this is higher than in civil proceedings. And the reason for that is fairness. So this higher standard of proof is meant to account for the inequality of harms between the parties, but also it meant to account for the seriousness of consequences of law enforcement for the person involved. So you can see how these values interplay when we think about evidence rules. And sometimes there may be difficult trade-offs to be made between the various values. And how the evidence rules are ultimately designed is essentially a reflection of these trade-offs. So that was probably a very long introduction to say that we need to keep all these things in mind in order to critically evaluate the proposals that have been made for changing the burden of proof, changing the standard of proof, as solution for addressing the under-enforcement problem in relation to killer acquisitions or beyond. And let me start with the first solution, which is to shift the burden of proof. And I want to emphasize that there are different ways to do this, and details matter hugely. So how you do it matters a lot. So a first option is simply to say that for certain types of mergers and/or mergers by certain firms, it will be for the merging parties to explain why the transactions should be allowed. And if you think about it, this option, option A, is practically akin to a rule of prima facie legality. So you start with the premise that these mergers should not be allowed, and then it's for the merging parties to come forward and explain why they should be. And just to give you a few examples, also in relation to the concerns about killer acquisitions, in the US, for instance, there is a proposal that acquisitions by covered platform operators as defined in the Act, this should be banned unless the platform operator is able to demonstrate one of the defenses that is exhaustively that are exhaustively listed in the Act. Or it has been suggested, for instance, that when you have horizontal mergers for which we know, based on economic theory, that they raise serious concerns and they're unlikely to be outweighed by efficiencies, then again, in this kind of situation, it should be for the merging parties to demonstrate why the transactions should be allowed. So these are some of the suggestions that have been made. And obviously, the thinking behind these suggestions is that there are certain transactions or transactions by certain types of firms that are both very likely to harm competition and consumers and very unlikely to generate efficiencies. So if we accept that as a starting point, one might say that actually shifting the burden of proof is justified on accuracy and efficiency grounds. It's not going to lead to inaccurate or too many inaccurate conclusions. And at the same time, it would expedite enforcement, and incidentally, it would also deter unlawful prohibition. I think the problem here is that this is quite a big if that's the case. At least it seems to me, I'm not an economist, but it seems to me that we haven't reached yet this level of consensus that, let's say, acquisitions of startups are so harmful that a reversal of the burden of proof at the decision-making stage actually is justified. And for instance, the EU experts report explicitly noted that we shouldn't go as far as assuming harm in that context. So if that's the case, then reversing the burden of proof raises three concerns. The first one is obviously that it may lead to over-enforcement, it may still innovation, also because we know efficiency claims are rarely successful. A second concern is about legal uncertainty, because it's not really clear to the parties what exactly they need to demonstrate for the transaction to be allowed, since there is no theory of harm that the authority has formulated in any given context. And also it may raise fairness concerns of things, going back to fairness as a value, to the extent that engaging in merger activities, in principle, it's part of the freedom to conduct business. Of course, it may be restricted, but also this is a freedom that, at least in the EU, it's constitutionally recognized in the Charter of Fundamental Rights. So, and one last point, beyond these concerns, it seems to me there is an important practical difficulty to bear in mind, that if we were to come up with a bespoke, let's say, rule on the burden of proof for certain transactions or transactions by certain types of firms, we need to be able to describe clearly in advance what kind of transactions are covered or what kind of firms the rule pertains to. And then much of the discussion, I think, or much of the effort will shift on, for instance, is this transaction a horizontal one? Or is this firm a firm with strategic market status or whatever? So that's an important difficulty to bear in mind, I think. Now, the second option is similar to the first one, but at the same time slightly different. And that is to introduce presumptions of harm that the merging parties will have to rebut. The difference here with option A is that this time the authority has to prove something. They have to prove the basis of the presumption. So they have to prove what I called earlier fact A. And again, there have been various proposals around that. In the US, for instance, it has been suggested that harm should be presumed, for example, where it leads to market share of more than 50% or otherwise significant market power, and the parties are actual competitors, or there is a reasonable probability that they might compete. In this case, we should presume harm. So that's one example. Or in relation to vertical mergers, again, it has been suggested that we should introduce rebuttable presumptions that will apply when certain factual predicates are satisfied. Now, in general, presumptions are indeed a very powerful tool to use. And when they have been validly endorsed, they can expedite enforcement, as I said, without undermining accuracy and fairness. But for presumption to work, A, their basis has to be as simple and clear and straightforward. And B, the drawn inference, the mandatorily drawn inference, has to be grounded in economic consensus, common sense, experience, and so on. And it seems to me that many of the presumptions that have been proposed are just too complicated. So if we think about the presumption that I mentioned, that harm will be presumed where, for instance, there is a reasonable probability that the parties will compete. That's not straightforward enough, right? So it seems to me this is quite similar, perhaps, to what authorities are doing anyhow at the moment. So I'm just a bit concerned that the efficiency benefits of presumptions cannot be really realized when you have presumptions that are so complicated, so complex, so complicated. So it seems to me that there is some merit in the suggestion for shifting the burden of proof in very limited circumstances, but not as a general solution to the under-enforcement problem. And that brings me to the second solution, which is to lower the standard of proof. And as most of us will know, at the moment, generally speaking, in merger control, the standard of proof is understood to be balance of probabilities. In the EU, there is a discussion at the moment about this because of the judgment of the General Court in E.CA Telecoms that said that the Commission has to show a strong probability. I think this kind of reinforces the concern that the standard of proof is too high, and that's why it's so difficult to block mergers that may be harmful. So the question is, should we lower it, even below a balance of probabilities threshold? And personally, my own view is probably not, because the standard of proof is a rule of horizontal application, so you cannot just lower it for one type of transaction. So if you decide to lower it, this is going to have a much broader impact across the board, and the concern again here is one of over-enforcement. So moving on, you may have noticed that I didn't give any examples here of proposed reforms, and there is a good reason for that. The reason is that many of the suggestions that have been made for lowering the standard of proof, in my view, they're just suggestions for changing the substantive legal test in merger control. And there are many examples here. So, for example, in Australia, it has been suggested that likely should be understood as remote possibility of harm. Or in the UK Furman report, it should be suggested that we should move from a balance of probabilities to a balance of harms approach, where you take into account not just the probability of something happening, but also the impact that it's going to have. Or moving away from a balance of probabilities to a realistic prospect of harm and so on. So what I find quite interesting is how confusing this language is, if I'm honest. Even though I have spent too much time probably thinking about these issues, sometimes it's very difficult to understand what goes to the standard of proof, what goes to the substantive test. But I think it's important to separate the questions because they try to deal with different problems. And also fairness, for instance, which is a concern in relation to evidence, is not really a concern when we decide what kind of risk we are willing to tolerate in merger control, for instance. So I think language is important. I think some of the suggestions make very little sense. So, for instance, that likely should mean remote possibility. To my mind, I'm not a native speaker, but to my mind, you know, this doesn't quite make sense. Yeah, so I think this raises certain legal certainty issues as a concern. But having said that, from all the solutions, in my view, this is the most legitimate one. It may lead to over-enforcement if that's a concern, but it seems to me that a democratically elected government and parliament, they might legitimately consider that this is a risk worth taking. So, where does this all leave us? In my view, the problem does not really lie as such in the applicable burden of proof or the applicable standard of proof or the applicable substantive legal test. Although, as I said, I'm not against making some limited changes to these rules. I don't think that's necessarily a horrible idea. But it seemed to me the real problem is just a different one. It's just that competition authorities at the time were faced with novel phenomena, novel practices, and they were not perhaps well prepared, well equipped to deal with these problems. And it took quite a bit of time for the authorities, but also for everyone, I think, if I'm fair, to kind of understand the problem and take action. So hindsight is always 20/20, and it's very easy, based on what we know now, to think back and criticize the authorities for what they did or did not do. So if this assessment is correct, then it seems to me the real solution long-term is not necessarily to change the burden of proof or change the standard of proof, but rather to ensure that we will learn from the mistakes of the past, for instance, by conducting ex-post evaluations. I think the Lear report was an excellent initiative, by ensuring that the agencies have the powers that they need to gather relevant evidence, that they have the expertise that they need, the institutional capabilities to take a more proactive approach to gathering evidence and understanding the problems, a point that was made in many of the panels yesterday as well. And I think we need to think more generally about the analytical framework that we use, the filters that we use, the proxies that we use, in order to then be able more easily to enforce the merger rules. And I just want to finish by noting, I'm not sure if I should do that, but by noting the Facebook gift merger that the CMA blocked, and the CAT upheld the decision just 2 days ago, I think it was. And if you think about it, the burden of proof hadn't changed, the standard of proof hadn't changed, even the substantive legal test had not changed, but the CMA was still able to block the transaction, and the court agreed that's the right decision. So I think what has changed ever since, say, Facebook, Instagram, Facebook, WhatsApp, is our understanding of these issues. And I'll just, it seems to me that this is really where the solution lies. It's not an easy solution, but it seems to me long-term is the best solution. And I would like to close by saying, fool me once, shame on you, as it says, fool me twice, shame on me. So I think that's where the focus should be, developing the necessary knowledge and making sure this is integrated, for instance, in agency guidelines and so on, to ensure that it will be easier for the authority to do what it has to do when needed. So thank you very much.
Thank you very much, Andriani, for bringing some conceptual clarity to this discussion about recalibrating the burden or standard of proof or the substantive legal test, and also perhaps bringing to the fore a more cautious note about some of the proposed policy initiatives. And I'd like now to just ask if there are any questions in the audience for Andriani. Amelia?
Thanks. I thought it was really interesting talk. And I mean, I'm on record on supporting some of those legal, the final set of recommendations that you made, but I equally can go on record as being very pleased about Facebook Giphy. And also, one of the things that we recommended in the Furman report was a rewriting of the merger assessment guidelines, which of course the CMA has done, and I think was helpful actually in enabling the kind of analysis that then occurred in Facebook Giphy and the CAT's kind of support to that. So I mean, that's something you didn't mention, but how guidelines can kind of change, even without changing the legal test, they can change the way in which the legal test is applied in a very neat way. But I just had a more specific question, which is your concern about the shifting of the burden, which is something I've always been a little bit nervous of myself. But it seemed to be mainly that it was a bit unclear about how you categorise which firms you would shift the burden on. And I was interested in your view on the kind of old style EU creation or enhancement of a dominant position test in mergers, because remembering how that was applied, it was pretty tough to show that a firm had a dominant position. But once, fairly tough, I mean, you had to get somewhere. I'm seeing Kai-Uwe shaking his head here. But once you'd done that, it was relatively a lot easier to show that there was going to be a creation or enhancement of dominant, the creation enhancement bit was relatively easier. And therefore, it's quite tough to get something into the category, but once you've got it into the category, the test, it's not exactly a reversal of burden, but it felt somewhat like that. And I just wondered whether, if you had that as your categorization, i.e., is this a dominant firm, would you feel more comfortable about something close to a reversal of the burden?
Yes, that's a great point. I just want to also echo what you said about guidelines. I think that's really an important step forward. So to make sure that, I like to call them economic premises, the economic premises on which merger assessment guidelines and guidelines in general are based on, that they are indeed sound, because knowledge evolves, we now understand much better certain things compared to the past. So I think the guidelines and updating the guidelines is an excellent way to also update, in a sense, merger control. Back to your point, I think in principle, there are many solutions, right? It depends on what you value and what you're willing to lose. So definitely, yes, you can say in relation to dominance, you can use the traditional test and say, oh, more than 50%, that's it, your dominance, nothing you can do about it. But it just seems to me, looking at how the Commission, for instance, justifies its decision, or how the court reviews these decisions, even though there is, as I say, a premise that yes, the higher the market share, the more likely it is, or there is a stronger chance that, yes, you may be found to be dominant. It seems to me that's not strong enough to justify a presumption And it's not also what the Commission or the court have been doing, because the Commission has never said, oh, you have 50%, I don't need to do anything else, I'm going to just lay back and just leave it to you now. So that's not how it works. It seems to me totally legitimate to rely on proxies, to draw certain inferences from the evidence and to demonstrate dominance or abuse or whatever you need to show. But I think pushing that to the level of a presumption, I'm not sure it would do more good than harm, but yeah, that's my personal view.
Thank you. I think we have still 1 or 2 minutes so if there's any urgent question for Andriani, we can take this. Otherwise, I would suggest we move on. So I think, Anush, do you have a question? Okay.
One was a relatively simple one. I was just wondering, do you see any possibilities of any conflict between competition authorities, like while implementing such a change of test when assessing mergers? Like, for example, the example of GE Honeywell came to my mind, and I was wondering, is there something on that?
I'm not sure I have the question. If there's any conflict between
if the Commission changes the test, so that you mentioned GE Honeywell?
Yeah, so any conflicts between commissions, would you have anything on how would you think you could address that?
I mean, if I'm entirely honest, I think if someone has changed something, that's not probably the Commission, but rather the court with the recent annulments, and that, of course, is going to have an impact on what the Commission does. I think the perception that it has become more difficult to find, let's say, an abuse of dominance or block a merger, I think that's not an incorrect perception. I think it is a justifiable perception. But it just seems to me that it is not because something has changed with the evidence rules, but rather because the shift to a more economic approach led to a greater emphasis on effect. Also, I think an important dimension to bear in mind, going back to the courts, is that I think the courts over the years have also started being much more thorough when they review Commission decisions. And then this has a knock-on impact on how the Commission does. That's why we see longer and longer and longer Commission decisions, because they just want to make sure that they cover all their bases to defend themselves. So I think it's a combination of factors. So yeah, if that answers somehow the question, yeah, thank you.
Thank you, and I think we should now move on to the third presentation by Emanuele Tarantino, who is professor in the Department of Economics and Finance at LUISS in Rome, and she will present a co-authored piece together, written together with Chiara Fumagalli and Massimo Motta. And to move on, you just have to click on your clicker.
Okay.
And I think then the...
Very nice.
Yeah,
it's wonderful. Okay, so first of all, thank you very much for including this and inviting me to present this paper in this conference. It is joint work with Chiara Fumagalli and Massimo Motta. The title has a bit changed over the last few weeks, and we now refer to optimal policy for mergers with potential competitors, going beyond the case of financial constraints. Okay, so the motivation for the talk is probably very clear by now to all of you, and given my previous the panel fellows' speeches, but it's about the acquisition of potential competitors for firms that are not yet on the market, or startups. I'm going to use startups in the rest of the talk, which has become a widespread phenomenon. You see, and this is a paper by Bruno Pellegrino, there's been a shift since the mid-90s in the exit of firms through acquisitions instead of IPOs. And this is clearly a prevalent phenomenon in the digital industry, but extends beyond that. You have a couple of papers very impactful referring to health and the dialysis market and pharma that document this is happening also beyond digital markets. So what is the what is the problem, what is potential problem, we try to see whether it is a problem or not. In the vast majority of cases, these acquisitions do not trigger mandatory pre-merger notification, so they go unchecked, and this gives rise to a phenomenon that Wallman in a recent paper calls stealth consolidation, so consolidation taking place under the radar. Okay. In the few cases in which an investigation was opened, the acquisition were mostly clear, even though something may be changing. You see Facebook Giphy blocked by the CMA recently, but also here we mention another couple of cases where the deal was abandoned in the end. Now, what is the research question of the paper then is to try and establish what are the conditions under which we should worry about such mergers with potential competitors and try to be active in proposing ways to screen such mergers. So let me take a step forward. So we come here at this point within a literature, the one on horizontal mergers, that is very well established, starting from Williamson paper and then the classic paper by Forrest Shapiro, that horizontal mergers trigger a trade-off between market power and the possibility that the new entity generates cost efficiencies. Now, the acquisition of potential competitors triggers an additional trade-off. And this is going to be key. Modeling this is going to be key in the analysis, in the formal analysis. On the one hand, the acquirer may engage in the takeover to shelve the project of the startup, and this is what is typically called in the literature killer acquisition. On the other hand, the acquirer may allow for the development of a project that would not reach the market otherwise. Okay? And so this trade-off, at least incorporating this trade-off in the analysis, is important to understand the pros and the cons of mergers of potential competitors, especially because this competitive effect may happen because the acquirer has resources that the target firm lacks. And in particular here, different from previous version of the paper, we refer to a broader spectrum of reasons why this may happen. Capital, so financial resources, but also managerial skills, market opportunities. What the acquirer has is basically scale. Is often referred to in the policy debate that the target firm lacks. Okay. So we ask, what merger policies should the antitrust authority follow? Now, let me give you a preview of the results, and then I enter the more formal part in which I sketch the assumption of the model, how we solve it, and the results, to go back to some questions about takeaways for merger policy and implementation. So first of all, and I was very happy to see Kai-Uwe's talk, because that's something I've been thinking about often during the last few weeks. So takeover price and acceptance decision, and this is a major takeaway of the paper, convey key information for the antitrust authority. In particular, a high takeover price signals that the acquisition may not be indispensable for the startup to make it in the market. And so this means that there are high chances that it is anti-competitive. So another takeaway that brings us to the first, but is the mechanism through which we get to the first, is that the merger policy can exert a selection effect. Okay, so this has been established also in other papers in which merger policies derived under asymmetric information. In particular, I'm thinking of Noke Winston, a paper of about 10 years ago. And there, the idea is that the policy pushes towards takeovers that target certain types of startups. And in particular, what we like is the startups that are not able to succeed on their own means. Okay? because these takeovers are superior in terms of welfare, independently of what the firm wants to do, in the sense the acquirer wants to do. Because if the acquirer wants to shelve a firm that's not going to make it to the market, we don't care. If the acquirer wants to develop, that's only good. Okay? So the stricter the merger policy, the stronger this selection effect. And strict here, I mean in terms of level of harm. So we have a model in which the authority can stand a positive level of harm. So in principle, there are situations in which authority may also accept that the merger is going to come with some welfare loss. Okay? And we try to determine whether this is optimal or not. In some cases, it is. So to activate this selection effect, the optimal policy indeed might commit to standard of review, so to cost in terms of welfare, that sometimes lead to a prohibition of a merger that is also increasing welfare compared to the status quo. So sometimes, and this is again a result that is common in Nokia Winston, sometimes to trigger this selection effect and get to the desired outcome, you may want to say no to mergers that are increasing welfare with respect to the status quo, because this pushes firms towards mergers that are more optimal from constrained optimal from the point of view of the antitrust authority. Okay, so this is basically probably we're taking a too bold statement here, I realize, but this calls to implement these takeaways calls for a change in the current approach towards acquisitions of potential competitors, at least in the ways we have seen it so far, even though things seem to be changing. Okay, so let me get into the formal part of the talk. So there are three players. There is an incumbent, there is a startup, and there is an antitrust authority. The startup is a project. You may think of a project in a very broad sense. It can be a new subsidiary product or a more efficient technology. The project development requires some fixed cost, we denoted by K. And now there are two types of startups. One is successful, and the other is not successful, unsuccessful. The successful one has the capability to develop the project independently of the acquirer. The unsuccessful cannot develop unless there is an acquisition. Now, in this context, we assume, in this model, we assume asymmetric information. So basically, the incumbent and the antitrust authority do not know with certainty whether the startup is going to make it or not in the market. Okay, so the startup knows its type. The incumbent and the antitrust authority are unsure whether absent a takeover, the startup makes it in the market, and they have a prior belief P. Now, you may think this is a completely absurd assumption. Here I'm putting a quote by the CEO of Excite at the time in which Google proposed a merger to Excite. It was 1999. And this is the quote, okay? I think the decision we made at the time, with what we knew, emphasis added, was a good decision. It's laughable to say that now, I suppose. So the CEO of Excite rejected the deal, and the deal was coming with a price of $1 million in 1999. So Google proposed to Excite to sell the code of its search engine for $1 million. After 6 months, the price was reduced to $750,000. And it came with another no. And the reason was that Google was asking for a major overhaul of Excite organization because they were very confident of what they could do. But Excite, with what you knew at the time, said no. Okay? So we know what is Google now. I don't think many of us, many of you, especially the youngsters, don't even recall what Excite is. Okay? So we are embracing this as part of our analysis. Of course, we also, the results don't change as a limit case in which authority and the startup and the incumbent have all the same information. Okay? So, different from the startup, if the incumbent acquires the startup, it has the ability, but not necessarily the incentive, to develop the project successfully. Okay? Okay, so as I said, there are multiple micro foundations to this idea there is asymmetric information. One comes from the fact that the incumbent doesn't know really if the firm has the ability to go on the market and gets funded. The other is that the incumbent knows exactly the cost of implementing the project, which can be high or low. Think about lack of managerial skills, lack of implementation skills. Okay? I think I don't need to spend too much time here. You just need to believe that the incumbent may have or may not have inferior information with respect to startup related to its type. Okay, so this is the timeline. The antitrust authority established the level of harm that it accepts, which again can be positive or negative. Then there is a takeover offer. Then the antitrust blocks or approves. Then there is an owner that decides on project development, so the owner can be the startup or can be the incumbent, and finally payoff. So here, the timing is such that there is a long-run decision by the antitrust to which the antitrust commits. That's important, but we're not the first, and I don't think we'll be the last to assume that there is commitment to this level of harm. And then there is the decision that implements the policy depending on the case of the merger at hand. Okay? So first of all, there is commitment to merger policies. It is a standard, ex-ante standard of review. And that's the level of harm that I was mentioning before, H bar, which if positive, corresponds to a tolerated levels of harm. So even welfare losses can be optimal. So then there is the takeover offer, and here there are two cases. Either the incumbent makes the offer or the startup makes the offer. You may, again, recall, Google made the offer to Excite. It may seem unreasonable, but we have a notable case in the books. Then the antitrust decides on the proposed deal under asymmetric information on the type of the startup. Okay? The antitrust faces the same asymmetric information as the incumbent. For simplicity, it's not fully sure whether the startup is able to develop or not. Finally, there is a decision on project development, meaning that the owner of the project chooses whether to develop or shelve. Okay? Now, here come the payoffs. I'm introducing notation. Just keep in mind that whenever there is a D, it corresponds to the competition case or duopoly case, and S and I are the payoffs in duopoly of the startup or the incumbent. If there is no development, there is a single product or less efficient technology, and we call it a small m, where W throughout the presentation is welfare, okay? Where pi are profits. If there is development, then there is a two-product or more efficient monopoly, and that comes with a big M. So big M is better than small m, but what is very good is D, okay? So big M gives more profits than small m, and small m is better than D in terms of profits, but what we really like is duopoly in terms of welfare delivered in the market. Okay, but we still like better a more efficient monopolist or a two-product monopolist. Okay, so there are a number of models, competition models that can be fit within these assumptions. So there are plenty actually. Okay, so project development is privately and socially efficient in the sense that the NPV of the project when the startup develops is positive. The net social value is positive with project development. WM minus WM small is larger than K, and a fortiori, even when developed by the startup, the social value of the project is positive. So development is the outcome we all want, ideally by both startups. That's the idea. Okay, so we start solving it. Okay, so we start from development. The startup always wants to develop. Remember, the net present value is positive. The incumbent's profit increase may be insufficient to cover the cost of investment. And so here we are basically put it into the model the error displacement effect, which is the assumption that is commonly done in this literature. And the idea is that it is necessary just to put some action, right? So there could be situations in which the incumbent wants to develop, and there are situations in which the incumbent doesn't want to develop. And we consider both cases. And we see that the merger policy does not depend on whether you want to shelve or develop, okay? So the incumbent may shelve a project that is successful, the successful startup would develop, and there could be, therefore, killer acquisitions. So killer acquisitions are part of our analysis and arise at equilibrium. Now, the action comes from the takeover game. So basically at the point in which the incumbent or the startup approach the other party and make an offer, okay? We characterize the perfect Bayesian equilibrium of this bargaining game, some technical assumptions. So the antitrust authority and the incumbent update their priors using bias rule whenever possible. This gives rise to some posteriors that we call phi. And posteriors coincide with priors when actions do not reveal type. Basically what it means is that if I make an offer to a startup such that both a startup that is successful and unsuccessful would accept or reject, I'm not able to learn from this acceptance decision whether the startup is good or bad, okay? Okay, so first of all, now I get to the, to showing you what happens. So given the welfare arm, having observed the takeover price and the acceptance decision, the antitrust authority need to basically decide, implement the policy decided at equals 0, right? So, and the approval is the outcome of this decision if and only if the authority attaches a low probability to the startup being successful. So if the posterior based on available information, which is price and acceptance, is low, the probability that attaches an authority to the startup being a successful startup is lower than a threshold FW, then I approve as an authority. Now, this threshold f of w depends on the decision of the incumbent to develop or shelve and the threshold of R. Now, what is the intuition? Well, if the startup is successful, then the takeover is welfare detrimental, because either stop developing a project or suppresses, and so suppresses para market competition or suppresses innovation. If it's unsuccessful, the takeover is welfare neutral if the incumbent shelves, because the startup would die anyway, but it's welfare beneficial if the incumbent decides to develop, because in this way it makes up for the difficulty in making it to the market. So this is telling us that if we can, we just want takeovers targeting unsuccessful startup, okay? Okay, so if the antitrust authority is certain that the takeover targets an unsuccessful startup, so this phi is equal to 0, then they should always approve. If the incumbent wants to develop, then this threshold here is higher, meaning there are it's easier for the startup to be approved. And if there is a lower threshold of harm, then the takeover is less likely approved, meaning that the antitrust becomes more strict. Okay, so here it comes what can happen, and then I'll show you pictures. So in any pure strategy equilibrium, independent of bargaining game power, we find two possible prices. Either a low price, at which only the unsuccessful startup accept the offer, or there is a high price, in which basically all startups accept. So this is how we build our conclusions regarding the importance of the price. If there are, independent of the bargaining game, independent of who develops or shelve, bargaining power, independent of who develops or shelve, we always find that there could be two prices, a low price and a high price. The low price is such that only unsuccessful startups accept. The high price is such that everybody, successful and unsuccessful, accept. So now I show you the picture. So this is the case with development. With development, you see that there are three regions. Above this Fi, the incumbent would offer a high price to the startup because it attaches a high belief that the startup is successful. However, there is the authority, and the authority doesn't like that. Remember, there is FW, and above FW, authority says no. So here the incumbent is forced to offer a low price. Below FI, the incumbent offers a low price. So the authority knows all this and knows that by changing H bar, it basically pushes the incumbent towards this region, which is the region in which, independent of the prior, there is only low price takeovers. So by making this welfare with level of harm negative in this particular case, so accepting only takeovers that increase welfare, the authority can get to this area where it is sure that only low price will take place and only unsuccessful startup will be acquired at equilibrium. So this is the selection effect. The selection effect is basically operating by moving H bar to the left, so to have that only these startups are acquired at equilibrium. If you keep a higher H bar, you may be here where some high price takeovers happen, which are better than no takeover because they increase welfare with respect to the status quo, but they're worse than low price takeovers. Okay, so the picture is fairly similar when I consider the situation in which the incumbent shelves, only with the difference that basically this H bar moves to the right and is always positive. It can never be negative. So this happens basically because here there are killer acquisitions. So it is the authority becomes stricter and FW becomes larger, ceteris paribus. Okay, so let me get to the optimal merger policy, and then I conclude. So the outcome with lower expected welfare is, across cases, high price takeovers. That's always the outcome we want to avoid as an authority. Now, the optimal merger policy then commits to standards of review that prevent high price takeovers from taking place. And when the incumbent shelves, it is enough to do what? To commit to sufficiently low tolerated harm. If the incumbent develops, you may even want to get to the situation in which you commit to prohibit takeovers that are welfare beneficial. Now, this may be optimal because it triggers a selection effect that pushes the firms towards low price takeovers. So for instance, an information-free policy doesn't depend on bargaining power, on development, and asymmetric information is one in which I take the minimum bar, the one that is stricter across those that I derived in the graphs, and I set that in my merger guidelines. Okay, so we have some extensions that, regarding the, for instance, we only focus pure strategy equilibrium, we consider also mixed strategy equilibrium, and show that everything goes. But I want to conclude with some policy implications. So our analysis shows that we should reconsider the current approach towards acquisitions of potential competitors. The antitrust authority should use information conveyed in the takeover prices, salient information regarding the potential competitive impact of these acquisitions. In our setting, these signals that acquisition may not be indispensable for the success of the startup on the market. This also tells us that we should introduce a transaction value threshold for notification on top of the turnover threshold. Something similar has been done implemented already by German and Austrian authorities. There is a threshold of 200 and 400 million across markets. It has been considered this proposal by the CMA recently. Okay. Regarding implementation, I think Kai-Uwe's talk is much more detailed than mine. So,
thank you so much, Emanuele. And I think you also put to the fore some interesting policy implications of your paper. And I just want to ask if there is a question. I think Farasat has a question.
Thank you, Emanuele. Faraz Bukhari from CCP. So my question is that this price that you're setting as the high price being a signal of it, Kai-Uwe is going to accuse me that I'm linking it to the pharmaceutical example, but there also, one of the things that we've seen in pay-for-delay deals is that the threshold has been set at what price you're paying over there, which can be that if it's higher than the litigation cost, it's a signal that there's something wrong over there. So I'm wondering if this type of a price type of a signal can then cause that there are side payments that will start off in these type of deals or takeovers, or whether there can be, because that can again be the same type of stuff that we saw in 90s in the other industry, and then it moved on to trying to find other ways of making the payments.
Absolutely.
So price can be a signaling problem. And second point, just follow up on it, while a high price may actually signal that there's something problematic with it, the corollary doesn't follow always that a low price, at least in other cases I've seen, is not problematic.
Yeah, so regarding the first, and then I go to the second question. So here what I mean by price is all the conditions that come with the acquisition, and not just the nominal price. Taking the price in absolute terms is probably misleading, but this is a model. Kai-Uwe's talk already gave us a framework to think about in terms of benchmarking. So the first question is, I think we should consider not just the nominal price, but all the conditions attached to the acquisition. Second, in terms of low price, if you have something more specific in mind, I'm happy to discuss. But in this case, in our model, low price basically signals that you're not able to make it to the market. In that case, you shelve or develop, I don't care. I mean, if you shelve, you're shelving something that's going to be die anyway.
There's been a second question by Jens.
Thank you. Thanks for a really nice talk and a really nice model. So I guess we can learn a lot from that. However, I have one kind of critical remark regarding the fundamental assumption, and that is that the startup knows its own type. So actually, even in the example that you mentioned between Google and Excite, Google apparently did not really know what its own type was. Otherwise, they would have never made the proposal kind of to sell their stuff for 1 million.
You know this because you read it? Because I read the facts of this Google Excite, and Google actually went to Excite saying, we're going to ask you for a major overhaul of the company because we believe our technology is much better than yours. So, not sure. In any case, that assumption can be dispensed and assume that everybody has the same information, or that the startup owns superior information and still need to, I think you already see this, high price, even in that case, is problematic because only those that have sufficiently high prior to make it are going to accept.
So I guess in the end it will be super important kind of to make sure how much you can relax this fundamental assumption. So if you say this is in the baseline model, and so I wanted to keep it simple, but kind of we can do it this more generally, and there can be noise or whatever. But this is really it's crucial because I mean it's all about either signaling or screening depending on who makes the proposal. And
So if you're so let me clarify this because it's important. So if you believe that it's better to assume that there is no asymmetric information whatsoever, then the results hold true. They're basically a case, sub-case of this. We don't think, if we assume that there is perfect information, they were going to come at us and say, for sure there is asymmetric information, and if you don't consider that, you're missing a point.
No, I'm not talking about asymmetric information. I'm talking about basically the fact whether the startup knows its own type or not.
Okay.
I've been in the shoes of a startup, and we did not know whether we were successful or not.
Okay.
We had some guesses, and in particular, we did not know what the competition was, which would then impact own chances. And I guess this is kind of a key thing.
Okay.
But it's just to clarify, my impression from listening to it was that what's key is the asymmetric information between the authority and the firms.
Yeah.
Within. That has something to do with the specific way of how you're modeling the bargaining and so on. And so there's going to be information revelation about whatever comes out of the bargaining. Right?
Exactly.
So that's fine, but I think you cannot, to your point, no one can know what's going to happen. You need to use the information that the firms actually have and judge on that basis, right? And in that sense, I'm not quite sure about your worry. So as long as you're using, as what's revealed is the information that the firms have that are doing the bargaining, that
I
should
buy
be okay.
that part. That's all good. The problem is it depends on the fact that that the price is a signal about the underlying value of the firm. But
Yeah.
my question is, what if the firm does not know its own value? Right? Because
But the firm is going to have priors regarding
Yes.
its own
Yeah.
value.
And that's
So-
the only thing I'm
then
That's what
then the
matters.
question is exactly kind of how noisy can these priors be such
Yeah,
that the
sure.
mechanism goes through. I do not doubt that it goes through, but I do not know it. I do not see it yet.
Yeah.
I think we should now move on with the two discussants. Alena Kozakova, the director at E.CA Economics and also former chief economist at Ofwat, and then Mike Walker, chief economic advisor at the UK Competition and Markets Authority.
Right. So you've had really excellent three presentations, and what I'm going to do, I'm going to reflect a little bit on them from the perspective of somebody who spent quite a lot of time on both sides, competition authorities, regulators, and consulting as well. So why are we here? We are here because there is this strong sense that there has been under-enforcement, in particular with respect to digital mergers. What there is a lot less sort of clarity on is what actually these killer acquisitions are. And I have a couple of observations, and my first one is that actually killer acquisitions are likely to be quite diverse. So the term comes from the pharma industry, where it's actually quite easy to see the harm. You have firm A producing a drug against, I don't know, diabetes, firm B producing a drug against diabetes, firm A gobbles up firm B, shelves the project. Easy to see the harm. Now, in the digital setting, you don't often see such a direct horizontal harm. You more often see vertical harm. Why? Because these markets are quite tippy. There is not much competition to start with. That's why we worry about them so much. So already you see a slightly different setting. I also think that we talked a lot about shelving, but the killing may not come from the shelving. If you look at, say, one of the decisions that were frowned upon lately, Google Waze, Google didn't want to kill off Waze. They wanted to use Waze because it was better than what it had. The killing was in the competition. No one else could use Waze as an input. Similarly, these mergers are not, from my perspective, just limited to these high-tech industries. We have recently done an ex-post evaluation for the CMA on vertical mergers, and only one of those cases we chose was a digital platform merger. It was Mastercard Vokeling. I'm going to say a little bit about it later. The other one was Heineken Punch. It was a very traditional merger where a brewer acquires pubs. And one thing we've learned about this industry was that alcoholic drinks producers regularly invest a little bit in a startup, a tiny amount of money in loads of startups, with the intention of, if it doesn't work, it doesn't work. But if it does work, we want to take you over. So, there's, again, no killing. There's a huge amount of promotion, if you want, of innovation, but not of competition. The competition, as soon as something is successful, it gets gobbled up. So, that could also qualify as a killer acquisition. So my second proposition is that, yes, digital mergers, the reason why we are here really, are different, but they're not completely different. And I would suggest that the reason why we are struggling to enforce against them as regulators, and why it's been such an easy ride for those companies so far, is that they combine things that the authorities are quite difficult at, are quite bad at tackling or find it very hard, which is potential competition and vertical mergers, right? And to make it worse, you combine those two. In our study for the CMA, we had that one example, which was Mastercard Vokeling, and there were loads of theories of harm. probably didn't need to be that many, but where we thought, to use Jens's language from yesterday, when music was playing, was that you had MasterCard, which is incredibly powerful, it's a duopoly in cards, and it might have been purchasing a critical input into interbank payments, which might be a potential competitor. So that's where the music was playing. We are not saying that the CMA got it wrong, but that is the nature of the concern, that you have potential competition with a vertical component. Two things that the CMA has not enforced heavily against individually, let alone in combination. So that's why it may seem like this is really, really difficult, but it may just be the nature of these deals. Now, one thing which we have noticed, and this is again linking to this particular case, which is really quite curious, there was one area where the CMA did find a problem. It found it on a horizontal level. It was in the cash part of the business, but not on the vertical. There was a mirror image, a mirror theory of harm, which was vertical, but the CMA didn't find a problem there. So there is something which kind of tells you a little bit about the tests, and maybe just vertical mergers are inherently more difficult for the authorities to look at. So that is, is it new? Is it that different? And the third proposition that goes to the legal test: is it broken? Does it need to be changed? One thing we have found in our study, which we thought was interesting, that the CMA tends to find entry stories really compelling, and tends to be quite harsh in the application of the foreclosure test, and that kind of applied to all the cases we looked at. It was very eager to discard something as a foreclosure issue. Again, we didn't think necessarily the CMA made a mistake, just there was this lack of balance. Entry, quite eager to accept; foreclosure, quite harsh on itself. So that is going to make enforcement against these kinds of mergers more difficult. Now, in terms of standard of proof, and they're sort of thinking about what it was like when I was at the CC, and we I did quite a few phase 2 mergers with a panel, it didn't feel like the burden of proof was 51-49. It really didn't. It felt like you had to have a firm conviction, to use Andriani's language, or some panels were just, beyond reasonable doubt. And, changing the language of the test is not going to change the practice. So I would not suggest that actually we need to change the test. The panels will need to apply them in some way. So one thing, so where this leads me is to say that there is this sort of perfect storm of potential under-enforcement, but fixing it by fixing the test, either the legal standard, is not going to help in any way. The CMA will have still the same panels and the same degree of approach to potential competition and vertical mergers. So that was a little bit sort of experience from those cases and my personal experience going back to my enforcement days. So what could be done about it? And I really thought that actually there were some really interesting thoughts from Kai-Uwe and Emanuele, because there is a risk now that we're going to throw the baby out with the bathwater, and we are suddenly going to presume that everything is illegal, when actually most mergers are going to continue to be benign. And I really liked just how practical Kai-Uwe's suggestion was. I'm sure that as soon as we start thinking how we applied, there's going to be lots of things that are going to come out of the woodwork. But I was, for example, thinking about the MasterCard VocaLink case. It would probably not qualify under that threshold. So actually, that might have been an easier decision then. Now, what I thought the CMA has done, and we've seen it in the 4 cases we looked at, there was this historic assumption that vertical mergers are somehow inherently less problematic. There's a lot of academic research, a lot of sort of almost ideological conviction that they're actually not as bad, whilst there is now, some of the literature was mentioned, Baker and the others saying actually you should take them equally seriously. So maybe we should remove any biases, positive or negative, and just sort of look at the cases as they stand. And maybe we need similar filters like we have in horizontal mergers. What I really liked about Kai-Uwe's suggestion, and actually Emanuele, yours would probably work in the same way, is to say, well, do you remember when we first introduced UPP and GAPPs? They were very similar, and they slightly actually changed. There was solution 1B of Andriani's paper. There were these sort of filters that would create effectively a rebuttable presumption. So you take two very easy inputs in the UPP, margins and diversion ratios, and say, look, this merger looks, and you're looking at that merger, you are not assuming anything about a category of mergers. This merger looks like it creates quite a lot of market power for the merged entity. Now, it's not a killer, but you now need to do some work to show us that there are efficiencies involved in this merger. And what I like about the deal multiples and employee multiples, that it actually creates a similar dynamic. You only focus on the cases that matter, and you have that sort of starting conversation. It's not no, this deal is a no, but it's, well, let's start thinking about all those complementarities and why it would be of such value to you as a company. So I really like that because it's easy to implement, it's easy to advise on if you are on the other side, and you can do something with it. And you don't need to change very much at all. That's, I mean, that was in some of the thoughts that I had just reading these three really excellent contributions. So they are not maybe that different, maybe that wider selection of these cases than we think. And maybe we just need to start using these filters on both sides. Maybe.
Thank you so much for your thoughts, Alena, and also for drawing again together the three perspectives that are put forward by the papers and working out also the synergies between the two papers. I hand it now over to Mike Walker.
Okay, I should start with my normal caveat that obviously I'm speaking on my own behalf, not on behalf of the CMA, but I mean, I don't think I'm going to say anything controversial anyway. If you think I have, you've probably misunderstood. So, first thing, look, I mean, I think all three of these papers are really interesting and good. The one I'm going to focus on is the one I think I probably misunderstood the most, but it'll be useful to get that misunderstanding out, because I think there's real issues. Andriani's paper, there's a real issue about this discussion and around economists and lawyers just talking past each other, you know, and I think we need to try and sort that out. But look, in general, before I get too specific, you know, I'm not a great fan of the language, killer acquisitions. Obviously came out the Cunningham et al. Paper where you genuinely have products being killed, pipeline products being killed. But you know, elsewhere we are, as Alena just said, we're just talking really about a dominant firm removing some competition that it doesn't like from a small competitor, and that's nothing really new. Okay, I guess that what is new is allowing for Alena's beer example. What is new is we are seeing this particularly in some of these tech areas where the future valuations of the companies are hard to tell, and the future pathway of their product development is hard to predict. And so that just makes the problem harder than it has been in the past. It doesn't, I don't think, mean that we've really got a different problem. And then one more general comment is Kai-Uwe very briefly mentioned this argument about acqui-hires, and you often hear, particularly from GAFAM, that look, it's not an anti-competitive merger, it's just an acqui-hire. You know, and I sort of think, well, hang about, okay, so for WhatsApp, you needed to pay $345 million per employee. I mean, and you sort of think, I mean, they may be good, but I mean, are they really that good? And you know, and even Instagram, you know, you're paying 75 million per employee, you know. And again, maybe Mark Zuckerberg just really liked Kevin Systrom and wanted to have him in his company, but I think they're buying a product. Okay, they're buying a product that is in the minds or in the IP of people, yes, but they're still buying a product. It's still therefore also it can be anti-competitive. Okay, so I want to come on to Andriani's paper, which I think is really super interesting. And I think it's just like the thing around burden of proof and probabilities. I really do think lawyers and economists talk past each other. Okay, and I'm not, it's going to sound like I'm saying in a couple of minutes, I think Andriani's wrong. I'm not saying that. I'm saying, as an economist, I don't understand why she's right. Okay, and therefore there's a debate to be had. And I think the Telefonica Hutch merger is a great example of this. No economist I know, except those working for the merging parties, think the Telefonica Hutch decision is anything but bizarre, whereas actually lots of lawyers think, no, that's right. That's a perfectly sensible decision. Not all lawyers, but lots of lawyers. Clearly, there's intelligent people on both sides. We have a different framework for thinking about the problem, and at the moment, those frameworks are not meshing, and I think that is potentially a problem. So I think, I'm going to take 3 propositions that come out of the paper, say why I disagree with them, and then maybe there's a debate. So I think 3 propositions that came out of the paper is it's important not to confuse a burden of proof with the substantive test. Those are often confused in the debate around digital mergers. And the standard of proof of mergers is more than 50%. It's not as high as criminal standard, but it's certainly more than 50%. Okay, I just think, from my perspective, as an economist working in the UK, I think all 3 of those propositions are wrong. I said I might be wrong. So, the confusion around digital mergers, I don't think when we talk about going to realistic prospect as opposed to likelihood, we're confused. I think what we're trying to do is we're accepting that the test we would really like in an ideal world, balance of harms, isn't implementable. Okay, what is implementable which might get us to somewhere close to the same position? Now, you might say that's an abuse of the test, but it's not a misunderstanding of the test. I thought it was a perfectly sensible sort of compromise approach. Okay, so you talk, Andriani, about these 2 probabilities. So the probabilities merger is going to be harmful, and then how sure we can be about that. And as an economist, that sort of thinking just does my head in, because I can't understand it. Because I sort of think, no, there's one probability, which is we've got all the information set out there, and on that basis we have to work out whether we think it's more likely than not that this merger will be harmful. And that takes into account our uncertainty around the evidence base. I don't think we're in a world where we say, okay, so we're 55%, the evidence is 55% sure this merger is a bad merger, and we're 80% sure in that 55% figure. No, hang back, that's a 44% figure we've now got to. So where did the 55% come to? So I do think there are 2 probabilities if we take this split, and I do think that leads to real incoherence. Okay, as I say, I'm really not saying you're wrong. I'm saying this is an area where economists and lawyers can, need to start talking to each other, because I think it can be a costly confusion, and I think it is a confusion that underlay quite a lot of the under-enforcement and led to people thinking, well, I think this is a bad merger, but I'm not really sure it's a bad merger, so we'll just allow it, because inaction and doing nothing is a safe option, So, you quoted Yoda. What's that? There is no try, there's only do or not do. And we've had way too much not doing, and I think this confusion has been part of that. Okay, the last 2 minutes, I'm going to talk about the other 2 papers, which I also really liked, and I think I understood them as well. So in the Kai-Uwe's paper set up the screen, that just, it seems really sensible. As Kai-Uwe himself says, it's neither necessary nor sufficient conditions. There's going to be a bunch of mergers that fail that screen, but which are absolutely fine. There's also going to be some mergers, GAFA mergers included, that pass that screen, but which are a problem. So I think particularly Google DoubleClick, that looks like, with the benefit of hindsight, that just looks like a bad merger, a really bad merger. But that wouldn't have failed the screen. So I think it's a really good initial screen. I think, as Alena suggests, it changes the debate. If you fail that screen, you've then got to explain why your complementarities are so high that they outweigh any possible anti-competitive concerns. And that's a really helpful reframing of the debate. So I really like Kai-Uwe's paper and that approach. And then Emanuele's paper, which I also really like. I think one of the things about it, actually, I found it quite reassuring, because one of the things you say is, look, there's clearly information in the takeover price. Absolutely, I agree, and we think that's true, and we make an effort to understand that what the takeover price is telling us. So, I think, we may not always do it successfully, but I think we're in the right place in terms of accept that and trying to do it. I do like, your point that, look, if you're paying a high price, you can't also tell us that you got a failing firm. You know, in a recent merger, we have had parties telling us, I know we're paying an enormous amount of money, but look, this firm's, it's a bit of a dog. And you sort of think, no, that doesn't really work, okay? So I think that's helpful. I do have a slight concern, going to Farasat's concern about gaming, and of course, if the total purchase price defined, including all the benefits, is totally transparent, fantastic. I do wonder whether that'll always be the case. And I always have a concern of these sorts of tests. And the idea of looking at purchase price, and of course that's been around for ages, has always been, okay, but can firms game that? And I still think that's an open question. Thank you very much.
Thank you so much, Alena and Mike, for your comments. I'd like to now invite very briefly the speakers just to react to the comments if they would like to. And perhaps Andriani, you might go first.
Yes, absolutely, yes. So thank you very much for the comments, and I don't disagree with you. I think the language is very confusing, and I think that's part of the problem. I think the reason for the problem, or at least that's my impression, it arises because when we think about these issues, we just tend to use probabilistic language. And I'll give an example to show that the two are different. The example I always like to refer to is cartels, right? So for cartels, we know that the standard of proof is, for the EU courts, firm conviction, which is arguably a high one because of the criminal implications. But then the threshold of harm is potential effects. So it seems to me that there is a difference here. So one might say, if we translate firm conviction into a probability, probably that will be, I don't know, depending on how you feel about it, it might be anything around, 75, 85% certain. But then the threshold of effect is not, I need to be nearly certain that the cartel has caused harm or will cause harm. We're going to intervene at a much lower threshold of effect. So I like to think this example when I'm struggling myself. And I think when you mention, for instance, the balanced probabilities, I absolutely believe no decision maker actually says, oh, you know what, 51% we're done here. So I don't think it works this way in practice. I think, and there is research actually showing that there is a strong correlation between quantitative expressions of the standard of proof and qualitative expressions of the standard of proof, even in the E.CA, where the probabilistic conceptualization of the standard of proof is more prominent. When it comes to criminal proceedings, we have beyond any reasonable doubt. What's the probability there? So again, back to my point, as I said, it's very confusing. In mergers, it's even more confusing because of the prospective nature of the assessment and the ex-ante nature of merger control. Yes, but I think there is still value in thinking about these issues separately. Also because, as I think I mentioned earlier, when we think about the standard of proof, we also care about issues like fairness, equality of harms between the parties, whereas when we think about the threshold effect, that's totally irrelevant. That's not what we care about. But I agree totally, the language is super confusing.
Thank you. Emanuele and Kai-Uwe, would you like to react to anything that has been said?
Yeah, just a couple of points. The first one on the last thing, I'm also always uncomfortable when I hear lawyers talking about the probabilities by which they do the decision in one, because I never know what the probability is. And actually, there's a connection to yesterday to these ranking systems. And we had actually, with a couple of people, discussion yesterday about, what do they mean to us? And the discussion came down to that we probably only can kind of think about like 3 categories or something, right? So it's like green, yellow, and red. Green, that's no problem. Red, there's definitely a problem. Yellow, it's kind of on the margin. And then you have to make a call kind of where it goes. And I think the question is kind of in the yellow region, you kind of say, we're actually looking at this carefully and then make a call how we feel it and how much information are we going to use. Or are we going to say, it's hard to deal with it, but let's kind of go in the direction and always say that's bad. Right? That's in a sense, that's the discussion we're having. And that kind of question is the one that concerns me, and where kind of the spirit of what I was suggesting also kind of goes in the direction of pushing against it. Namely, yes, you want to limit what you're looking at, but you actually want to have kind of a deep set of cases that you're looking at in order to learn. Because we have a couple of things kind of in competition policy. For example, if you talk to the Germans about retail price maintenance, they know, well, we have a lot of experience, it's always bad. Because they have basically a per se prohibition where it's never used and they've never evaluated whether it was bad or not. It's just because it was bad, it's bad, right? So that way we're not actually gaining experience. I think here, and I think that came out of some of the discussion as well, is that we've actually learned quite a bit about these things over time, and that these, as you said, kind of the decisions are getting more informed. And we don't want to cut that off. And I think that's the spirit also of having something where you're selecting what's worthwhile reviewing without overwhelming your agency in terms of doing that. And I think that's one of the really important things. I think one thing in terms of your endorsement of something like the German thresholds of value, I think they're actually bad thresholds because they're not telling you value relative to what. I think that's really the important insight that has to come in, and that also came in from what Faraz had said, kind of in the patents issue, there is a reason to compare it with a cost, right? And so there's a natural benchmark. Here, the proposal is to benchmark it with what it currently is. I wanted to make one thing because I can't leave it there from what you said about this when you basically said, oh, they're always saying these are acqui-hires, and WhatsApp and some of these others aren't acqui-hires. I think no one would disagree with you that those aren't acqui-hires. We're really talking about a massive tail of hires that, for example, Google has that are extremely small firms where it's not the product that they're and it's above 50% of the transactions.
I agree.
Okay, and I think we need to be very clear about that because I think the firms aren't saying anything else than that. Well, certainly not in the conversations I've had, right? But we're creating the impression that those are potentially the difficult transactions, and I think they aren't. I think the Instagrams are. I'm not sure how much the WhatsApps is, but you know, but I think it's also a case-by-case issue. But those are where there is a product that is of substance, where you actually have a real value that you can attach to that, not the transaction that's 500,000 or $1 million, because that's what you're paying for the value of the guy that you're bringing in. And I think being very clear about this, I think also from the agencies, is just helpful to kind of lead that discussion in the right direction.
Emanuele,
very fast.
Okay.
So I agree on the reference point. Of course, we don't have one theoretically defined, but your analysis to me makes a lot of sense. I mean, this multiple thing is I completely shared. No, regarding the difficulty of implementation, we discussed two in the paper. One is misreport the acquisition price. But again, there is one, probably is misguided, but there is the market, right? So if you go and say to the market, I'm going to buy this guy for 1 million versus 200 million, there is going to be also an impact on what the market thinks this acquisition is worth. And that, it's not necessarily good, no, for the acquirer. So there is a force there, but we also have disclosure requirements across board. So you want to acquire and you are Google, so give us all the conditions that are attached to the deal. And then we see what is the price, what is the side payments, what is the other sweet deals that you want to do. I mean, but this we can do. It's common in financial regulation. So,
thank you so much, Emanuele, as well. And I am afraid that we have to draw this to a close now. It has been an extremely stimulating discussion, and please join me to thanking the speakers and also the discussants for this panel.